I'm David Rogers, and this is the first in a series of informative videos about the law in Texas. Joining me today will be Tony Reed, a regular practitioner in the area of real estate law and eviction. About forcible detainer and eviction and what happens in Texas. And the first thing that happens is you get a 3-day notice to vacate. What is a 3-day notice to vacate, Tony?
3-day notice to vacate is the landlord, or in the case of a foreclosure, the bank saying that you have 3 days to vacate, or if you don't vacate, they will file suit. So it's not a real 3-day notice to vacate, it's a 3-day notice to vacate, or they'll file suit. So you have more than 3 days.
So if I get a 3-day notice to vacate, I should not move in 3 days. I should call a lawyer. And when I call that lawyer, what's the lawyer going to tell me?
Lawyer is going to tell you you have more than 3 days and you better get into the office in order to find out what's going on and how to stop it.
And those 3 days go by. How soon can the bank or the landlord file suit against me to try to evict me out of my house?
They can file the suit on the 4th day. The suit cannot be heard for 6 days from when it is delivered to the resident.
But it has to be heard within 14 days, isn't that right?
I believe so.
Yeah. And in Texas, you don't have to move until after you get a judgment against you from the court. Isn't that right?
That is correct.
And is that lawsuit normally filed on the 4th day, or does it normally take them a little longer than that?
It can take them, they can file it on the 4th day, it can take them a week, it can take them 2 weeks, it can take them even longer.
Sometimes as long as a month or 2.
Yeah.
And then after the lawsuit is filed, it'll be scheduled to be heard in the local Justice of the Peace Court sometime between 6 and 14 days after you get served.
That's correct.
And when you go to the Justice of the Peace Court, who is the Justice of the Peace? Is that person a lawyer?
The Justice of the Peace might be a lawyer, does not have to be a lawyer. Justice of the Peace is the judge that is empowered by the Constitution to handle forcible detainer suits.
And just to be clear, a forcible detainer suit is what we call an eviction suit under Texas law. And what is going to happen when you're in front of that Justice of the Peace?
The Justice of the Peace will listen to both sides and determine who has rightful possession of the property. And
will there be testimony? Will you be sworn in?
There could be testimony. There should be documents. The other side should have documents to prove their case, and you should have documents to counter their case if there are any documents.
And if you have a lawyer there, can your lawyer potentially prevent them from entering evidence into the record?
It depends on the Justice of the Peace, but yes, your lawyer can prevent some evidence from being entered.
Are the rules in a Justice of the Peace Court the same as the rules in every other court in Texas?
They are not the same. There is a special...
Okay, and are the rules in a Justice of the Peace Court the same as the rules in every other court in Texas?
No, they are not. There is a special set of rules under the Texas Rules of Civil Procedure for forcible detainer, and the judge is not required to use any of the other rules of procedure or of evidence, but can if the judge chooses to.
Now, am I required to have a lawyer if I want someone to represent me in a JP court, or can a non-lawyer assist me?
A non-lawyer can assist you, although a lawyer is more capable.
Now, is it possible that the bank or the landlord will be represented by someone who's not a lawyer?
It is possible, but not likely, that the bank would be represented by anyone but a lawyer. The landlord in an eviction suit for non-payment of rent, not related to foreclosure, it's highly likely that it will be someone other than a lawyer.
And if I lose in JP court and the JP issues an order for me to be evicted, how long do I have?
You have 5 days to do something. If you do nothing within 5 days, on the 6th day, the other side can get a writ of possession from the constable, and the writ of possession is a 24-hour notice to vacate.
Is there anything that I can do if the justice court judge rules against me?
Yes, there is. Within 5 days, you can post a bond and file an appeal to the county court at law.
Now, if I go to the county court at law, can I represent myself? Can I have a friend represent me? Or do I need a lawyer?
You can represent yourself. You cannot have a friend represent you. And it is a good idea to have a lawyer.
So are the rules different in county court when I'm on appeal than they are in JP court when I'm arguing this in the first place?
The county court at law judges tend to be more stringent with rules of evidence and rules of procedure, but the rules of procedure covering forcible detainer or eviction apply.
Are county court at law judges lawyers, or are they non-lawyers like some justices of the peace?
County court at law judges are going to be lawyers.
And if I win in the county court, then what happens?
I'm not sure.
If you win in the county court, the bank or the landlord may, if they want, appeal to the Court of Appeals. If they win, you can, if you want, appeal to the Court of Appeals. That is a separate procedure. The Court of Appeals is a separate court, and usually whoever loses in the county court will have to post a bond in order to appeal to the Court of Appeals. Those bonds vary enormously from judge to judge, from court to court, and depending on the facts. They can be as low as a few $100s and as high as many tens of thousands of dollars, depending on what the facts are. However, if the bank or the landlord loses, they can simply refile in the justice court. And when they refile in the justice court, does the fact that they lost in county court or the justice court before have any effect on their new case?
No, it does not. It is a case that is retried as if it had never been tried before.
Well, that doesn't sound fair. It sounds like there's one set of rules for the landlord and the bank and another set of rules for the renter or the homeowner.
That's what it seems like.
Tony Reed, thank you very much for joining us to discuss what happens in a forcible detainer action in the state of Texas.